A warm welcome to everyone to this beautiful evening. Today we have Advocate Dr. Sudhakar Awad sir as our speaker. It is an honor for me to welcome Advocate Awad sir on behalf of RERA Practitioners Association Pune and Bar Association Maharera and Maharit Mumbai. Sir, your presence is highly appreciable by all of us. I also welcome all the participants who are excited to hear our speaker. Last year, during the pandemic started and the lockdown had started, that is in April 2020, we first started our series of webinar, and Advocate Awad sir was the person with whom we started our first webinar. Sir had delivered a lecture on overview of RERA Act and comparison with MOFA Act. Sir, it is pleasure for all of us to have such a great personality among us. We are all keen to hear from you, sir. Thanks for taking out a time from your busy schedule to share your thoughts and to guide us. I once again welcome you, sir. I request Sujata Bhave to kindly introduce our today's speaker, Advocate Awad, sir. Over to you, Sujata ma'am.
Thank you, sir. Good evening, everyone. I am Advocate Sujata Bhave, a representative of the Pune RERA Association. The initiative of the Pune RERA Association to conduct these webinars is slowly based on its determination to contribute in assisting lawyers to enhance their skills and knowledge. In order to work towards our vision, today we have organized this webinar on the topic Title Certification and Responsibilities of Advocates. Our speaker today truly requires no introduction. He in his field of teaching, since he is teaching in his field since the year of 1977. There are numerous advocates and judges who have become successful today with his coaching. As he speaks today, most of you will recollect the days preparing yourself to be a successful advocate or a judge under his guidance. He has received several awards and has written several books on, and the recent one being the Real Estate Development and Regulation Act 2016. Now, without any further ado, I request you, sir, to take the floor and share your insight on our topic. To you, sir.
Thank you. Thank you, madam. Thank you, Nilesh ji. I'm very happy to be with you this evening. I'm really thankful to RERA Bar Association and Maharera Advocates Association, Mumbai, for calling me for the lecture or giving me this opportunity to deliver a lecture or rather dialogue with you people. And that is in respect of title certification and the responsibilities of advocates. Friends, after discussion with Nilesh ji, this topic was selected or chosen by us. This is especially the branch of conveyancing, especially in Maharashtra. Those advocates who undertake the conveyancing work as a part of the civil practice, which involves drafting of deeds and documents, registration of such documents, and issuance of search and title certificates and reports. In this behalf, before we proceed to understand how we shall conduct the process of title certification, let us first try to understand why at all it is necessary to understand this branch of title certification. Branch of title certification, friends, is very vital nowadays, because when I had been in the Bar Council as a member and as the chairman 20 years back, and thereafter also I am associated in different forms, most of the complaints against the advocates are regarding professional misconduct, and most of the cases relate to search report and title certification. Not only this, but on many occasions, there are criminal cases instituted against lawyers for giving improper or rather wrong title certificates. There had been cases when notaries and advocates were booked for giving bogus, false or erroneous title reports and certifications. It is said in the practice, friends, as a lawyer, you have to defend your client, you have to protect his interest, but at the same time, you must learn to protect your own interest. By acting as a lawyer, you have to protect your own position, and usually my experience for so many years in the practice and in the Bar Council tells us that most of the time, the problem or the trouble is created not by the opposite party, not by the opposite client, but by our own client. And therefore, friends, let us in today's dialogue ensure that we, as a lawyer, giving or issuing title report or search report, are not committing any errors within the meaning of issuance of the title report as per statutory provisions. You'll ask me that whether there is any law regarding lawyers or advocates which fixes liability on us. And yes, friends, at the outset, I will say that there are three provisions wherein we as the lawyer are responsible. First, there is a provision in Advocates Act of 1961, Section 35 thereof. Then there is a provision in Section 3 of MOFA Act. And then thirdly, there is a provision in respect of the RERA Act regulations issued by the Maharashtra state. Especially at these three places, as per RERA, as per MOFA, and as per the Advocates Act, we, the advocates, are responsible while issuing such search report and title certificates. What sort of liability we may incur if, say, for instance, we have not done our job correctly, we are negligent, then in such a case, in what way a lawyer may be responsible for consequences of such false or rather erroneous or title certificate issued under negligence. And friends, there are three categories of the responsibilities. There are three categories of the consequences. First category is in respect of the professional misconduct. Under Section 35 of the Advocates Act of 1961, there is always that hanging sword on the head of the advocate. If there is any negligence on his part, then there is a case made out in respect of professional misconduct. And then, as you know, there are disciplinary actions by the disciplinary committee of the Bar Council of Maharashtra and Goa, and ultimately the Bar Council of India, subjected to appeal to the Supreme Court. Therefore, friends, there is hierarchy in respect of such cases to be tried by Bar Council of Maharashtra and Goa, then by the Bar Council of India, and then appeal to the Supreme Court. So there is a professional misconduct for which there can be a punishment, reprimanding or suspension of a sonar, that is license to practice for some time, or this license to practice may be suspended forever also. These are various aspects in respect of professional misconduct. That is one of the consequences in respect of such a erroneous title report issued by us. Second is exceptional, that there can be a criminal liability also. We're going to discuss a couple of judgments of the Supreme Court, the Bombay High Court and Delhi High Court in this behalf, wherein it has been held by the courts that a lawyer under what circumstances may be criminally liable for the consequences. If there is a case made out of joining hands with the builder or with the bank officers, and there is any fraud committed at the instance of the advocate, or he joined the hands with them by issuing wrong or erroneous title report or title certificate, then he will be criminally responsible. And then thirdly, civil responsibility. There can be responsibility in torts. Responsibility in torts will involve as to payment of damages by an advocate issuing such an erroneous certificate to the person in whose favor or who has been banking on such a certificate. Especially, this is the consequence as stated in the provisions of MOFA Act and within the provisions of RERA Act regulations. Based on this, you will find, friends, after reading entire Civil Procedure Code, I come across only one provision, that wherein lawyer is responsible to pay the cost and to pay something out of his pocket. That is in respect of Order 32 Rule 2. In respect of Order 32 Rule 2, when there is a suit instituted by an advocate and suit is instituted on behalf of the minor without an ex friend, If it is not properly instituted suit, then plaintiff is taken off the record and cost of such litigation are to be borne out by the advocate who presented such a plaint. That was one case wherein I found that lawyer is responsible to pay something. Second is the case in respect of title reports. If there is such a title report issued and because of it there is some fraud committed or there is some damage committed to other party banking or relying on such a search and title report, then very well advocate will be responsible for the consequence. So to proceed further, let us bear in mind that for wrong title certification, for erroneous title certification, we can be civilly liable, we can be criminally liable, and we can also be professionally liable in respect of the Advocates Act. These are the three consequences in respect of such a title certification done by us. Therefore, we have to be clear in our minds as to issuance of the title certificate or how title certificate is to be issued, how there can be a liability on the advocate to be provided. This liability on the advocate is fixed by virtue of, firstly, the MOFA Act. We know all of us, we are practicing on this side of the civil practice. The Maharashtra Flats Regulation, Promotion, Construction, Sale, Management and Transfer Act 1963. In this act, there is section 3. Section 3 of this act provides for the consequence. It says general liability of the promoters. General liability of the promoters. 1. 3 into bracket 1. It provides for various documents which promoter shall deliver to the buyer of the flat. And secondly, sub-rule 2 into bracket A provides that there shall be true and full disclosures as to nature of the title of the promoter. Therefore, that true and full disclosure as to nature of the title of the promoter is supported by the certificate issued by an advocate. Here we come, and here comes our role. It is not simply we are giving title certificate at the instance of the promoter or in the instance of the bank. This certificate issued under the MOFA Act is a statutory consequence. Therefore, for breach of this, there can be a statutory liability fixed in furtherance of MOFA Act. Lawyer's liability is not merely in respect of the Advocates Act, but also in respect of the MOFA Act. And then, friends, we come to the third aspect. Third aspect is in respect of the RERA, the Real Estate Development and Regulation Act of 2016. Therein, the rules have been framed by the state in the year 2017, and as per that rule, there has to be no encumbrance certificate to be issued by advocate. We'll discuss in the course of the discussion. As per the MOFA Act, a lawyer or advocate having standing or practice of not less than 3 years shall issue such a certificate. Considering the seriousness of the problem, practicing age has been enhanced. As per MOFA Act, any advocate practicing for not less than 3 years can issue such a certificate. However, in respect of the second act, that is RERA Act, certificate shall be issued by an advocate having such a standing practice of not less than 10 years. That is the consequence in respect of the two acts and the consequences thereof. Based on this, now we come across the consequences in respect of advocate and what is the liability of an advocate. In respect of such advocate's consequence or liability of an advocate, we have to have the brief survey thereof. Let us see a brief survey. How in past lawyers had been, advocates had been held responsible for the consequences of the negligence on their part. It may be rather incapacity of the advocate to understand or his negligence. Friends, try to distinguish between two things. A person may be very competent but negligent. Person is very diligent but incompetent. Nevertheless, consequences in respect of loss caused to someone. This issue has been discussed by the courts in couple of cases. I will not go to the all facts, detailed facts of the cases, but nevertheless, important facets of the cases we shall be discussing. First of all, such cases was the case of Ramanik Lal Tulsidas Kotak versus Varsha Builders and others. Case was decided by Bombay High Court and has been reported in AIR 1992, Bombay at page number 62. Judgment has been delivered by Justice D.R. Dhanuka of the Bombay High Court. In this case of Ramanik Lal Kotak versus Varsha Builders, issue was before the Bombay High Court that in what way certificate can be issued and what is the responsibility of an advocate. Law has been given, law has been laid down in detail by the Bombay High Court. Bombay High Court has said in para 19 of the judgment of Justice D.R. Dhanuka, Lordship has specifically stated before issuing any title certificate by the advocate, he shall address himself as to the title of his client. And therefore, advocate has to address himself as to title of his client, that is the promoter. Means what? To address himself means to study in detail. We shall study in detail the title of the promoter or the builder in respect of the property upon which construction is being carried on. If there is no proper investigation by the lawyer, then he will be responsible for the consequences. In this case, we will discuss again at the concluding part of our lecture today that while delivering this judgment, Honorable D.R. Dhanuka of the Bombay High Court has categorically said lawyer has to take abundant precautions. He has to take utmost precautions while issuing such a certificate. First, we generally do not do it, but we have to do what? First, he says, Lordship said, first you get an affidavit from your own client. You get an affidavit that these documents, that's true copies or copies, etc., I have given to my lawyer. And get another affidavit from him that I have not subjected this property to any encumbrances. And thirdly, said by the said judgment that at least public notice should be given in 2 newspapers. Public notice shall be given by an advocate in 2 newspapers, one in a vernacular, say for instance in Pune Marathi, and in another is in English. Friends, let us have the introspection whether we do it. Many times lawyers, they are because of the nearness with their client or the faith on their client, we generally do not follow such practices. Something wrong comes out of it, or something wrong happens out of it, and any flat purchaser is aggrieved thereby, then we as the advocate certifying the title of the builder will be responsible for the consequences. Detailed guidelines have been given by Bombay High Court in Ramanik Lal Kotak's case. Then this was one issue as to Section 3 of the MOFA Act and liability of the advocate in respect of title certification. Then second is the case wherein there was a criminal consequence involved. That criminal consequence was in respect of Central Bureau of Investigation versus K. Narayan Rao, decided by the Supreme Court. And that case has been decided by the Supreme Court, which has been reported in 2012-9 SCC, page number 512. Justice Ranjan Gogoi and P. Sadasivam, they have decided this case. This was relating to bank transactions. We see today, many of our brothers and sisters, they are on the panel of banks. They are on different financial institution panels. And while being on institution panel or bank panel, we have to issue such reports in respect of loan transactions. In respect of such a loan transaction, such a certificate was issued by an advocate. Ultimately, it was found that bank officials, persons in between, they have committed a fraud on the bank to the tune of few crores of rupees. The version of the CBI was the advocate involved in this case is also to be joined as an accused because he had joined hands and he was hand in close with the criminals. Therefore, he should be joined as the criminal participant in this case. Issue ultimately had been to the Supreme Court. Issue had been to the Supreme Court whether this Advocate K. Narayan Rao is responsible in criminal consequences for giving erroneous search report. And here the Supreme Court very explicitly has said, no doubt, if lawyer has intentionally joined hands with them, then he will be criminally responsible. If he has joined hands with the criminals intentionally, then he will be responsible for the same. If, however, a lawyer, while certifying title report or issuing title report, he has said and he has taken sufficient precautions in his report itself, then he may not be criminally liable. So, friends, there is a very thin line when we are liable and when we are not liable. So as to save our neck from the criminal consequences while issuing search report, we have to ensure that every precaution is taken while issuing such a certificate. What precautions is to be taken, we are going to discuss hereafter. But in this case, ultimately, the Supreme Court acquitted and it was clashed against the advocate in the Supreme Court. But you'll find, friends, from the trial court up to the Supreme Court, going there itself is a punishment for the advocate. Let us take proper precautions, otherwise we may be criminally liable for the consequences. Similar cases to be found in the case of S.M. Yadav versus Central Bureau of Investigation. Such cases of frauds, when the amount is huge, when amount in crores of rupees, there are such huge financial frauds, cases are referred to CBI. And especially notaries and our advocate brothers and sisters issuing search reports that involved in such cases. In this case also, this Yadav and Company was a law firm. This Yadav and Company was a law firm and they were acting on the panel of a bank. They issued a search and title report in this behalf. However, it was committed by the borrower and it was contended by the Central Bureau of Investigation before the Delhi High Court ultimately that this advocate, his therefore to be joined as matter ultimately from the trial court, it came to the Delhi High Court. When matter came to the Delhi High Court, issue was whether a lawyer can be criminally liable and whether in the present case he is criminally liable. You'll find, friends, in that case, Justice Gupta of the Delhi High Court has held a lawyer can be criminally liable also. In the earlier case, Justice Ranjan Gogoi has also held that a lawyer can be criminally liable. But fortunately, in both the cases, considering the facts, nature of the case, was found that lawyer was not responsible because he was not party to the fraud. Giving false report is different. Giving erroneous report is different. And joining hands with the criminals is different. On that issue, and very that thin-edged aspect, those two advocates were saved. Otherwise, there could have been a criminal liability also. The issue is very simple. Sometimes we say that there is no proper title report is issued. There is no proper legal advice is given, and there is wrong legal advice is given. These two terms to understand. So, and there is wrong legal advice is given. If there is improper advice given, if there is impropriety in the title report, lawyer may not be liable for the consequences. But if there are such consequences wherein statements are made, whereby with reference to that, there is a wrong legal advice, a wrong conclusion by the advocate, while issuing title report and certificate, he will be responsible for the consequences. What is difference between wrong legal advice and improper legal advice? Try to understand. Try to understand. This saves our neck. If it is improper, you are saved. If it is wrong legal advice given, then you are not saved. Consequence is whether there is moral delinquency or not, whether there was active participation or not. If there was no active participation, you are not liable for the consequences. If, however, you have joined hands with the others, you will be criminally liable. So, let us distinguish between the two. If, as a lawyer, you did not understand the consequences of any given document, you wrongly interpreted the documents and have given a wrong certificate, is one thing. And you have deliberately given such a wrong is different thing. In the first case, you are wrong, but not liable. In the second case, you are wrong and also liable in the provisions of the law. That is the consequence in respect of improper certificate and in respect of the certificate which is a wrong statement of law and fact, then you are personally liable for the same. The issue is, you are liable for what? Negligence. And what is negligence? When there is a care expected from you and you are not discharging your duty properly, you are not taking proper care, then for the consequences, you are responsible. What is standard of care required? What is standard of care required in such a case? Nice illustration has been given by Juris Saman in his book on torts. He says that there is a stitching required by the shoemaker and also stitching required by the surgeon. Is the same standard required? And it is said that there is no same standard required. Likewise, in respect of an advocate, what care we must take? What amounts to negligence in respect of breach of duty on the part of the advocate, and has been explained by the court in the case of Joseph Matthew versus State of Punjab, reported in 2005 into volume number 6, SCC, page number 1. In this case, the court has explained the standard of care expected, the standard degree of care expected from a lawyer. When you are issuing such a title report, are you expected to discharge the duty at par with, say, great lawyers of the Supreme Court and High Courts, or senior lawyers of the High Court and Supreme Courts? Say, for issuing such a certificate, say for instance, are you expected to be like Kapil Sibal, Abhishek Manu Singh? And here you will find, in this case, Supreme Court has observed, in respect of professionals, let us expect reasonable care. Here we come to further discussion. This is the bridging gap between, or this is the bridge between our first part of the discussion and second part of the discussion. What is the degree of the care? What is the standard of the care expected from the lawyer while issuing this report, search report and title certificate? What is search and title? While doing it, what he is expected to do? What is that word reasonable relates to? And has been explained by the Supreme Court in Joseph Matthew's case. It has been said, in respect of professionals, wherein doctors are included, wherein lawyers are included. And it is said here that we expect from them standard care expected, and that standard care relates to the ordinary test to be applied. It is not that higher expertise of the towering personalities is needed. What average advocate understands, what average advocate will issue such a certificate is the test to be applied in such a case. That is the consequence in respect of the lawyer, in respect of an advocate issuing such reports. We are liable for different consequences, and therefore, friends, we have to take utmost care while issuing such cert and title certificates. Who are agree with them? See the dimensions which we commit a mistake. Say, for instance, I am taking a search report in respect of some agricultural land, and there is some wrong committed. Judgment, there is a error in judgment of the advocate while issuing search report. Purchaser is affected. Only the purchaser is affected. While in respect of such search report and title certificate issued in respect of any MOFA Act or say RERA Act, wherein there are a couple of hundreds of people are buying the flats, then you'll find, because of advocate's wrong report, advocate's erroneous report, so many people, they will be affected. They have taken bank loans, and especially they have been paying EMI for the same. Those people will be the sufferers. And law therefore protects to the victims ultimately. An advocate in such a case may be liable for the consequences. If there is judgment error, he may be excused. But if there is negligence, in due diligence, getting of the title of the promoter or the builder, he will be liable for the consequences of his negligence. How this standard of care is to be taken, how precautions we shall take, that we'll understand hereafter, being the second part of our dialogue. The second part now, friends, it relates to the consequence in respect of conveyancing and its consequences. You'll find, friends, this entire law relates to property. It is said there is a proverb in Marathi. What is the basis of all disputes? Kanak nahitar kanta. Kanak means gold. Kanta means woman. Therefore, it is said basis of all litigations is to be found in two parts. Either it is property or morality. It is property or morality. And therefore, one of the basis of the litigation is property. And therefore, this property of the society, Jurist Hobbes, you must have read in jurisprudence then. Jurist Hobbes, in his treatise, well celebrated book called as Leviathan, he has said that property is the basis of the society. It is the axis on which the society rotates. The persons having no property, they develop a tendency to become property of others, that is slaves. Therefore, friends, property in any society forms the basis of the society. And we, the lawyers or advocates, frequently are required to draft deeds and documents for transfer of the properties or in respect of securities created or mortgages created or the incidental documents in respect of such transfers. Friends, earlier it was very easy to draft such deeds and documents because it was agricultural land in a village or small villages and towns. Everybody was knowing everybody, all of them. If A was selling his land to Z, people were knowing whether it is owned by A, what are the problems therein, and whether Z will be safe or not. Nowadays, in cities, towns, there is no such acquaintance with each other. In the absence of acquaintance with each other, there is a danger of frauds being committed. And therefore, nowadays, conveyancing has become a specialized branch of civil practice. We, civil lawyers, we shall take utmost care while issuing such search report and title certificates. What is search report and title certificate, friends? It is also called as due deliberations or waiting of the title. In respect of due deliberation or in respect of search and title certification, it has two parts: search and title certification. Search is a process which, before the amendment, it was in the offices of the sub-registrar manually. When we started the practice, then we, as a junior lawyers, used to go to the sub-registrar's office, pay the fees, and make the physical search, and then make the entries thereof. Nowadays, after amendment, I think after 2002 or something, now there is no need thereof, and you can provide for the payment of fees, and then you can get the search from the sub-registrar's office. Nevertheless, for all documents, you have to go and take the physical search thereof. This is search. Usually, who is carrying out such search? See any senior's report. Senior usually, because of his age, because of his standing, because of commitments, he's not in a position to go and attend such very many sub-registrar's offices. Therefore, what he usually is doing, he usually deputes one of the juniors or colleagues, and he says that go and you carry out the search. It is good work for the junior lawyers. It gives them livelihood as well as good experience. At the same time, friends, use the responsibility. They have to provide for the manual search as well as this e-search, and then it provides for the basis for issuance of the search report at a later stage. This is one part. Second part relates to the deeds and documents and revenue extracts to be read and analyzed. First, it relates to the record of rights and extracts thereof to be seen, to be analyzed, And secondly, various deeds and documents. These are two parts of our process of title certification. In this process of title certification, when we are required to issue such a certification of record of rights and extracts of record of rights, then we have to understand in little bit detail. When you are practicing on this side of the civil aspect of the course, then let us have in 2-3 minutes time how this system of record keeping started in India. And especially you'll find it goes back to Kautilya. Kautilya has made a detailed provision in respect of land and in respect of revenue to be paid to the state. But in the systematic form, it started in India in the year 1540 during the period of Sher Shah. He provided for payment of land revenue on crop value method. Or money conversion, payment of revenue to the state during Shah period. Then really this system was modernized by Todarmal, who was minister of Akbar. Emperor Akbar and his minister Todarmal, he provided for rather a scientific basis for the land and assessment. He provided for survey of the lands, and during a period of 1571 to 1582, he completed the survey within the empire of Akbar, and system was based on that. Then there was Malik Ambar, who was at Ahmednagar, who provided for fixation of land revenue and the methodology to be adopted. Especially during East India Company, method was adopted by them, and they were doing such trial and error methods. They were carrying out experiments in India, and carrying out experiments in India, they were stating various aspects of the lands, the crop classification, its value, etc. But Britishers, they were jealous too. They were providing for experiments to come up with the modernization of the entire system. Accordingly, there was a field classification, survey numbers provided as per the Britishers' plan. Especially you'll find today, we get village map. Village map was prepared for the first time in India in the year 1838 under the directions of the British people. And then the conversion of the land revenue in terms of money was done on rupee scale in the year 1840. From 1840, this land revenue is payable in terms of rupees. Then it was rupee, ane, etc. Rupee, ane, pai, etc. Now it is in rupees and paisas. This system started in the year 1840. This system was provided, especially the entire system was going on, but its revision, its modernization was done at Indapur in Pune district in the year 1868. In India, during British India, in the year 1868, first proper method of assessment was laid down at Indapur. And then there was an act passed by the Britishers that was called as the Bombay Hereditary Offices Act of 1874. And then there was an act called as the Bombay Land Revenue Code of 1879. And there was a comprehensive scheme in respect of survey numbers, then areas, and then recovery of the assessment. This was thereafter amended, and in the year 1903, there was the basic amendment effected in Bombay Land Revenue Code. When there was basic amendment introduced in the year 1903 and 1913, you know that as per the Britishers, there were various inams given, and therefore there was Inam Commission appointed. Inam Commission submitted its reports in the year 1858, and in furtherance of that, such Hereditary Act was passed. And when this Hereditary Act was passed, you know that there are two things we understand: Kodai Patrak and Alienation Register. Almost all lawyers, they ask for two documents for a search: Kodai Patrak and secondly, Alienation Register. Especially you will find in respect of watans or inams, the consequences are to be found in alienation register. While in respect of ownership of the land, that is to be found in Kadai Patrak. And you'll find therefore from 1913, 712 extract came into existence. What is the basis of 712 extract? Where from those details were taken? Those details were taken from the erstwhile document maintained during the British period called as the Kadai Patrak. From the Kadai Patrak, those details they came to be borrowed and now they are included in the 712 extract and our land revenue code. Then friends, based on this, we come to the next part. After independence, entire law has been changed. And there is a sea change introduced in this land revenue in the form of Maharashtra Land Revenue Code 1966. Let's see. As per this Maharashtra Land Revenue Code 1966, what are the provisions regarding land records? I'll be brief, we know, because land records itself can be subject for lecture itself. I'll be extremely brief. But nevertheless, before we read the 712 extract, before we analyze 712 extract, before we make any entry as to search report, let us see what is this record of rights. And this record of rights and its value is to be seen. And while giving search report, while issuing search report, we have to see that entries in the record of rights, they are not creating any ownership, and that is simply of the ownership, but they are not creating any ownership. Therefore, in respect of the Maharashtra Land Revenue Code, record of rights is provided in the chapter comprising of section 147 to section 159. Section 147 to section 159 provides for record of rights, while record in respect of unoccupied lands is provided in sections 160 to section 167. That we know in respect of unoccupied land means, unoccupied lands means those lands which are still in the possession of the government, and especially in respect of such government land, unoccupied land which are not allotted to anybody, then in respect of such land, there is a provision as to Nistar Patrak and Wajib al-Arj. Especially in respect of such unoccupied lands, how they shall be used, that is decided by the collector of the district for the benefit of the villagers. While the first part, section 147 to section 159, they relate to record of rights. They relate to record of rights, wherein it provided that for each village there shall be a record maintained. It is duty of the state. And so there are two things. Say for instance, if any person, he was having his rights in respect of any property, then that was as per the 712 extract, as per the old system. However, if there is any acquisition of rights after 1966, acquisition of rights may be how? Either that can be by act of the parties, that is transfer of property under the provisions of the Transfer of Property Act of 1882, or that can be under succession, Hindu succession, Muslim succession, or other successions, or there can be testamentary succession by will. So by any method, if any person, he gets any right in respect of any immobile property, then he has to report it to the village officer, to the Talati within 3 months of such acquisition of rights. He has to report to the Talati. Once he reports to the village officer or Talati, then such village officer or Talati, based on that, he will make entry in the book. That is called as pencil entry, rough entry. And then he will give notices to all concerned who are concerned in that land. And he will post a notice thereof at a conspicuous place in the village called a chowdi. So notice is given to public in general and also to the persons in particular, if they have got any objection. If they have no objection is received, then Talati, he will provide for the certification of the entry. And that will be further confirmed by the circle officer. That is how entry becomes final. This is called as 6D entry. We'll discuss at a later stage, but that is finalized. That is how acquisition of right, when reported to the officer, that comes into record of rights, and accordingly, record is corrected to that extent. If there is a dispute created, then revenue practitioners know If this process happens and at some point of time, when a dispute is created, then Talati will not make such 6D extract, but that will be register of disputed entries. Register of disputed entries, and that is under the control of the tenancy awal karkon or person of his rank or hierarchy. He will decide the cases, and then further proceeding called as RTS proceeding starts. RTS proceeding is started, and therefrom there can be the Mamladar deciding the case. Then there can be first appeal to the deputy collector, second appeal to the additional collector, and then revision to the commissioner of revenue in the division. That is how RTS matters they are decided. What is RTS, friends? We write R full stop, T full stop, S full stop. If you read entire Maharashtra Land Revenue Code, or if you read any law, there is nothing like this R full stop, T full stop, S full stop. There are no RTS proceedings. Where this RTS came and how that is followed, this RTS proceeding came by a tradition. When during British period, Britishers were trying the cases in respect of lands, then they were saying these are the cases relating to rights. Cases relating to rights. What is the short form of the rights? R capital, short, small t, small s, rights. Rights, that was put into short form of RTS, and that became RTS ultimately. This RTS is nothing but short form of the term right. Therefore, when there are matters relating to rights, that is called as RTS proceedings. If there are no RTS proceeding, then that entry becomes final. There is further provision made nowadays, friends. Because of this e-registrations, it is provided that in each of the village, there shall be electronic devices provided for registration of the documents and deeds and entries. So also, there is a provision. If any document is registered under the Indian Registration Act, then in respect of that immovable property, that extract of that document, intimation of that document shall be sent by the registrar concerning village officer. We as a civil lawyers, we usually find that never this happens. One hand of the government, that is the registration department, never sends it to the other hand of the government acting under the Maharashtra Land Revenue Code, that is Talati. We ourselves, we run in between from the pillars to the posts. We run from the office of the registrar to the office of Talati for entering our names in the record of rights. Nevertheless, by this process, our right is created, and then that is reflected where by a registered document, my right is created, and that is reflected by of entry in the record of rights. So try to understand relationship between seal deed executed of any land in favor of a person, and then his name is entered into the record of rights by mutation entry. Then that mutation entry in the 6D extract, entry in the 8A extract, or entry in the 712 extract, that is not creating right in me. That right is created by the seal deed only. That right created by seal deed is reflected here. This is simply the proof of that right, but this revenue record is not creating any rights in this behalf. That is the consequence. Especially you'll find in 712 extract, after digitalization, there is some change effected, as we know. But generally, in this 712 extract, we must understand and we must analyze 712 extract properly. How to do, we'll discuss hereafter. Especially, you'll find the second act provides for Indian Registration Act of 1908. The Indian Registration Act of 1908 provides for two aspects. Especially, there are documents which are compulsorily registrable document as per section 17, and other documents which are not so compulsorily registrable under that act yet registered. And therefore, in respect of such registrations, there are 5 categories of the books maintained in this office. First, book number 1, wherein documents and memorandum in respect of immovable property, they are registered. Book number 1. In this book, especially those documents under section 17, 18, and 19, they are registered of the Registration Act. That is book number 1. book number 1. Book number 2 relates to the reasons for refusal. Book number 2 relates to reasons for refusal given by the registrar for denying the registration of any document. 3. Book number 3 relates to wills and authorities to adopt. This is a book in respect of the wills and authorities to adopt. Then comes book number 4, and that is documents not relating to immovable properties. In book number 4, registration in respect of documents not relating to immovable properties or miscellaneous documents that are registered in book number 4, while book number 5 relates to deposit of wills. Register of such a deposit of wills. It is not registration of wills. That is done in book number 3. In book number 5, will is not registered. Will is deposited for registration in a sealed envelope. Then that is registered as per book number 5. Based on this, there are various indices issued. Index is singular. Indices is plural. Ekvachan, anekvachan. We say always say index 2. What these indexes are is provided in this act. So, as per Indian Registration Act, index 1 relates to names and additions of the persons in the deeds and documents. If we ask for index 1, that provides for names and additions of the persons. If we go for index 2, then particulars of the documents, under section 21, they are provided in index 2. Usually we go for index 2 of the document. All particulars under section 21 of this act are to be found in index 2. And then index 3, that provides for names and particulars of the persons regarding will. And then the index 4 relates to particulars in respect of the book 4. These are technical things we have discussed. Based on these technical things, from the record of right, from the Land Revenue Code, and from the Indian Registration Act, now let us come to lawyer's job. Hereafter, say for instance, you have asked your client that bring this document and bring that document, and you are now sitting for analyzing the documents. Once documents are collected from these different sources, especially by application of these two laws, then once document come on your table, how you shall analyze them. And especially while reading, interpreting, and understanding the revenue record, you have to just read one judgment in this behalf. Judgment is very interesting. That judgment, name of the judgment is Namdev Panduranga Khedkar versus Shashi Gupta. That is reported in 2014, volume number 3, All Maharashtra Reporter, page number 592. In this judgment, various aspects, various facets, various colors in respect of land records has been explained by the court. It is said in this judgment, ultimately, revenue record is not a document of title. It has a presumptive value, but it is a proof of the ownership, but by itself, no title is created. That is the consequence in respect of Panduranga Khedkar's case. You read that judgment. The consequence is to be found how to provide for and how to go for analysis of the title of any person to that particular property. And matter is very simple. Friends, first, if you take the 712 extract, before digitalization and after digitalization, there are only 1, 2, 3 changes expected. Otherwise, it is the same thing. Especially you'll find, first always read so as to understand the nature of the interest of the particular person. We have to see what sort of interest he has, what sort of ownership he has, and especially such person's ownership may be either holder or occupant class 1, or holder or occupant class 2, or there can be government places. You have to understand. It is said all lands that are held by the sovereign, all lands are owned by the state. We are the authorities, the occupants, we are the holders. It is a misnomer to say we are owners, we are holders, we are occupants. Especially the Maharashtra Land Revenue Code uses the word holders or occupants. So we are occupant class 1 or occupant class 2. There is a difference between occupant class 1 and occupant class 2. In respect of occupant class 1, there is no restriction as to alienation of the property. For transfer of the property, there is no permission is required. There is no restriction. I can transfer such a property without anybody's interference and anybody's prior permission. Then that is said to be occupant class 1. Occupant class 2 is a different thing. In respect of occupant class 2, I am owner, but nevertheless, my transferability, its alienability is subjected to the control from the government or some agents. That is government part. Therefore, it is said to be occupant class 2, usually Inam lands or Watan lands, etc. And then comes the third category, government leases. Sometimes government lands are leased out to different persons, then therefore different tenures on different terms, and therefore such person is holding such lands subjected to the terms of the grant in respect of such a person. So land is owned by the state, we are a grantee only. In one of the lectures, a young advocate asked me a question. Sir, even though you say that government is the owner, but say for instance, a person he owns agricultural land, or a person he owns any building, then he is owner of that agricultural land for generations together. Then where is the question of state becoming owner? And then I gave him simple illustration thereof. I said, look, it is true that when person is holding any agricultural land as a grantee, as occupant class 1 or holder class 1, then he is as good as absolute owner, but he is not absolute owner. Ultimate ownership of the state prevails. How come? How we can prove? Say for instance, take simple illustration. There is a provision in Maharashtra Land Revenue Code. If a person intentionally fails to cultivate his agricultural land for 2 or 3 years consecutively, then what happens? Even though I am owner, can I intentionally keep my land un or non-cultivated for years together? If I am owner of house, I will keep it locked. But if I am owner of agricultural land and I am not intentionally using it for years together, then provisions in Maharashtra Land Revenue Code will apply. What is the consequence? Most of you know. Kai sherasto sarkari no akari pad. As soon as this happens, the holder's name is cut therefrom. It goes to other rights column and government's name appears in between. So government is the ultimate owner. Again, it goes to the government. That we shall keep in mind in respect of such land. And therefore, while assessing the title of the given person, we must see whether he is holder 1, he is holder class 2, or whether he is government lessee. Accordingly, the nature of the right will be decided based on this. Secondly, we have to understand that whether in such agricultural land, was there any tenant, or whether there is any tenant. You'll ask me a question, sir, that it is a long story of 1948, when there was the Bombay Tennis and Agricultural Lands Act of 1948. And as per that Act of 1948, we understood as per section 32G, such tenant in possession cultivating such land, he statutorily became the purchaser. Such person becomes a statutory purchaser. Then question comes that when we are in the year 2021, in this 21st century, whether there is any need to refer to such tenancy. And friends, yes, we need to refer to such tenancy, because nowadays you will find that there are various provisions in that act, especially section 32F. In that act, there is a provision as to section 32F. If such person, especially is incapacitated person or happens to be widow, then what happens to Tiller's Day? That Tiller's Day of 1st April 1957 automatically gets extended because of what? Because of the consequence of such landlady being widow. If landlady becomes widow, then that Tiller's Day is put in abeyance. Tiller's Day is never postponed. Consequence of Tiller's Day is postponed till her death, till her widowhood. And therefore, even after 1957, we have to see carefully, even today we have to see carefully whether there is any tenant or not. There are different classes of tenants we have to see. There can be ordinary tenant, there can be protected tenant, or there can be a perpetual tenant. We have to understand that properly. Not only this, but we have to see whether such person is cultivating the land personally or not. Such person, if he cultivates the land personally, that is necessary in this connection. Otherwise, as per old 712 extract. In digital 712 extract, this is not stated. But in old record, it was stated as Reith 1, Reith 2, Reith 3, Reith 4, and Reith 5. Whether landlord is cultivating himself or he was cultivating it through someone else, the Reith 1 and Reith 2. If there was tenant, Reith 4. If in respect of such a tenant, there was a sharing of the crops, 4. If it was in respect of money, 5. And therefore, there was such a mode of cultivation stated in the 712 extract itself. Accordingly, right of such tenants were to be considered. Protected tenants, perpetual tenants, they were then entitled to become statutory purchaser by virtue of the provisions in section 32 to section 32R of the Bombay Tenancy and Agricultural and Lands Act. Today, the Maharashtra Tenancy and Agricultural Lands Act of 1948. Friends, hereafter, we have to relate to the consequence in respect of whether land is being cultivated or not. In cultivation column, it is usually the crop inspection usually done in September every year is stated. Otherwise, if it is uncultivated, there is word per. So land is uncultivated and is not subjected to taking up the crop by the landowner, that is stated there. Then we go in respect of title tracing of such agricultural land. We have seen the philosophy. Now let us go to the actual consequence. If in respect of any property of which earlier it was agricultural land, how you will trace the history? While tracing the history, first we have to make a table. First we have to make a table in respect of mutation entries. So as to have the flow chart of the title, you have to maintain a flow chart of the title. Who was the earlier owner? Then who was the next owner? Who was the next owner? Whether there was a transfer, whether there was a succession, etc. So make a table like the mutation entry number, then nature of the transaction and the consequence. Then in fact, we'll get the flow of the title itself, how from A to Z property has been transferred. And then only first this has been done. Secondly, judge the contents of the 6D extracts. Not only arrange in the tabular form, but in the last column, you have to state what is the effect thereof, whether they have been correctly done or not. Because if it is not correctly done to your knowledge, you have to bring it to the knowledge of your client and tell him, look here, this is not correctly done. So he may require some correction in the same. Especially you will find in respect of deeds and documents. What is the meaning of the term deeds and documents? When you have to take search of any property, what you have to provide, ask for all relevant deeds and documents, copies thereof first, and then inspection of the original second. It is better you always inspect the originals also, but in the beginning, ask for the copies. Make a list of all the documents. Once you make the list of all the documents, usually we come across 3 words: deeds, documents, and indentures. What is the term indentures? If you read the drafts of solicitors, then they are titled as indentures. What is the meaning of the term indenture? Do you know? To indent means what? To indent means to cut uneven. So friends, in those days, what happened? When there were no proper methods of registration provided, then such a transfer was effected. When such a transfer was effected by a document, it was written at home in the presence of panchas or witnesses. And then that was cut in between. That was cut in between. Half part was given to you and half part was retained by me. Those cuts were to be fitted into. Whenever the document was brought together, then that was brought together, that was fitted. That intended part, uneven cut part was put together. Therefore, such documents are called as indentures. Then there are deeds. Deeds are of 2 kinds. Either deeds are deed polls, or they can be bilateral or multilateral deeds. Deed polls means there is only one party. Deed polls means there is only one party, like power of attorney. I myself give a power of attorney. This is deed poll. While there can be bilateral documents like agreement to sale, like a sale deed, there should be bilateral or multilateral documents. Such bilateral or multilateral documents we have to read. How to read the documents? If it is simply said it is a sale deed, and we shall presume that it is a sale deed? No, friends. When any document is given to you and there are 6D extracts entries, then first see contents of the document. As a lawyer, we have to see the contents of the documents. In the contents of the document, what we have to see? Why it is necessary? And sometimes you'll find there are conditions imposed. You'll find there are different parts of the deeds and documents, but there is a recital part. Recital part usually provides for the title flow or the history of the title of the owner, transferor, reasons for the transfer. While the contents provide for the covenant sometimes. There are assurance given and that relates to ownership, possession, payment, etc. Say for instance, friends, if it is a sale deed, name has been entered into 6D extract, name has been entered into 712 extract, but in the sale deed it is said that price is fixed at XYZ rupees, of which rupees X they have been paid today and remaining amount to be paid in this 6 months time. What sale deed is executed? What will happen? As a lawyer, as an advocate certifying, we have to take a note of the contents of the sale deed also. Simply there is a sale deed is not sufficient. Say in the given case, you say that it is unpaid sale deed. Some part is paid and some part is not paid. In respect of the unpaid part, say for instance, owner, the remaining 10 lakhs amount is to be paid. You pay him 10 lakhs thereafter. Never to do it. Your client shall do it. How? You shall advise your client, look, that sale deed was registered. Unpaid amount is stated in the sale deed. So that receipt for the remaining payment shall also be registered. And that will be a complete set of documents providing for the such consequence. So see the recitals, see the covenants, see the conditions therein. Especially you'll find why we go for 30 years documents. Usually it is said go for 30 years search. That is in respect of especially regarding the mortgages. So it comes to now encumbrances. When assessing the documents, you have to see whether there are any encumbrances on the property or not. As per the RERA Act, you have to give no encumbrance certificate also. It is not merely search, it is not merely title, but also no encumbrance certificate. And such no encumbrance certificate is to be issued by you. What is encumbrance? We always say that there are no encumbrances. Jala Marathi मध्ये आपण बोजा नाही असं म्हणतो. What is this encumbrance? Encumbrance is some enrollment on the title. Say that owner has got a title, but some other person has created some interference in his title. Maybe right of way, or say maybe some payment to be made, maybe some benefits to be conferred on, etc. So you have to verify. If it is by registered deed, if it is a registered deed, then that is provided here. By registered deed, what happens? By registered deed, entries are effected in the record of rights in other rights column. In the extreme right column, in the 712 extract, such entries are effected whether there is any encumbrance on the property or not. That is to be seen. If that is seen in the record of rights, then you have to certify accordingly regarding the encumbrance and ask for the proof of such encumbrance and release from the same. This is in respect of agricultural lands. This is especially in respect of villages and small towns, but especially in big towns and metropolitan cities. Now, after the invent of the 1963 MOFA Act, the Maharashtra Ownership Flats Act, usually called as. Thereafter, now there is a different aspect provided. Now people, they come to you not only in respect of land titling in Pune city, but most of the transactions, they are pertaining to apartments or flats or shops. Now friends, it's different to give a title report in respect of agricultural land, but it's different to give a search report in respect of one flat in 100 flats building or a complex. There are 100 flats and shops. You are giving title report in respect of one flat. And therefore, when you are interpreting the provisions of the MOFA Act or the Maharashtra Ownership Flats Act of 1963 and rules of 1971 made thereunder, then look here, you have to understand that land is owned by A. Then builder has constructed the building thereon. He has sold 100 flats to 100 people. They have formed a society and conveyance is made in favor of the society. What is nature of the rights of the member in the property? Say for instance, I am having this flat. In respect of this flat, I am member of our society, whether I am owner of this flat. Technically speaking, legally speaking, land and the building stands in the name of the society. I am the allottee thereof, or I am having rights as the member of the society. And therefore, while certifying the title of such owner of a flat, you have to certify accordingly. The flat is owned by the society, land is owned by the society, while Mr. A is the member of the society. In that capacity, shares have been issued to him, and accordingly, he is the person occupying the flat and is entitled to hold the such flat in that capacity. Such details shall be stated therein. Matter becomes more complicated, friends. In respect of Apartment Ownership Act, in case of MOFA Act, in case of society, there is collective ownership of all the members together. But in respect of Apartment Ownership Act of 1970, what happens? Land is developed by the builder. Land is owned by A. Builder has developed it. He has constructed, say, 10 or say 20 apartments thereafter. And then he is not forming a society, but he has subjected such land and the building to the provisions of Apartment Ownership Act of 1970. Then you will find land is subdivided, no. But you have got right in the property, yes. As in case of MOFA Act and collective ownership of the society, in case of Apartment Ownership Act, flat is owned by me, because in respect of Apartment Ownership Act, builder or the owner of the property, he provides for drafting and registration of what? Firstly, deed of declaration and bylaws. And in addition to that, there is a sale deed executed in my favor. In case of a society, only one sale deed and only one document. In case of Apartment Ownership Act, the document is the deed of declaration and bylaws, and secondly is the consequence in respect of what? The deed of apartment, or in respect of sale deed of the apartment. This you have to see, and such documents are to be verified by you. Then we come across a different consequence. In cities, you will find there are bungalow societies or plot owner societies, and the society owns the plots. Say that it is plot owner society. Society owns the plots. Plots are allotted to the members, and member has constructed a bungalow thereon. Who owns the plot? Society. Who owns the bungalow structure? The member. Such a concept of dual ownership is very unique to Indian situation. As per Indian law only, such is position only in India. In India, plot can be owned by the society, but structure is owned by me. And therefore, while certifying such a title in respect of bungalow plots, you have to certify. There can be another aspect, that there is a plot of a layout, but it is a freehold plot and there is no society form. So on freehold plot of layouts, then plot is owned by me. There is no society now. And in respect of my plot, I have constructed a bungalow or a structure therein. Then what happens? In respect of thereof, there can be rights of ownership with the owner of the plot. Now there is no dual ownership. He owns the plot and he also owns the structure thereon. That is how divisibility of the title is to be verified and is to be seen by you. Based on this, friends, we come across the concluding part. Concluding part is, based on this discussion, as you have analyzed the title documents, you have seen the 712 extract, you have seen the record of rights, various forms therein, and also verified the deeds and the documents. Then ultimately, you have to see what? That judgment of Ramniklal. In case of Ramniklal Kotak's judgment, Bombay High Court has laid down that once you do it, get the advocate, get the affidavit of your client. Also, issue public notices in two newspapers, one in vernacular and other in English. And thereafter, you issue the search. If you have got any doubt about the title of the owner, then you have to make mention in the title document. In Ramniklal judgment, very frequently question is asked to the lawyers. Can we, the lawyers, issue conditional search report and a title certificate? There cannot be conditional search. There can be conditional title report issue. After due deliberation or after waiting of the documents, can a lawyer or advocate issue such conditional title report? And has been observed by the Bombay High Court in that Ramniklal's judgment. Yes, advocate is entitled to issue conditional search report. Conditional title report stating therein specifically his queries. And also, if there are any defects in the title, then lawyer, advocate is also empowered. He's entitled, rather, his duty bound to state what are the defects in the title and how the developer or any given person, he has to cure such defects in the same. Especially you'll find based on this, the advocates, they have to safeguard themselves not only against the purchasers, but also against their clients. Usually cases are filed against the client, against the advocates by their own clients. Usually we find that when we win the case, everything goes well, then you are not blamed. But something goes wrong, the first person to be blamed is our own advocate. So we have to ensure against our own client first, and then to fearlessly do your work intelligently and deliberately. If you do your work deliberately, then there is no negligence. There is reasonable degrees to be seen. What is reasonable is a question of fact. What is reasonable is a question of fact. Depending on the risk involved in the matter, you have taken sufficient care. You have analyzed the document. You have asked for all documents. You have asked for all record of rights. You have made it in a tabular form. You have provided for the flow chart, and you have also provided for contents of the document duly analyzed, and then you have drawn your own conclusions. If you are doing it, then there is no malice involved. There is no negligence involved. Maybe any lawyer, say for instance, a junior lawyer may be less competent, but he is not negligent. Law will not punish you for your less competency. Law will not punish for your incompetency, but law punishes you for your negligence. So even though someone may be incompetent, but let us see that they are not negligent. Friends, with this I conclude. This was a subject in a lighter vein. Nowadays, we are all bothered about the different aspect in the society. Something is going on in the society whereby everybody is uneasy, and therefore Nilesh has given me such a lighter topic to be discussed, nothing to be taken at home, but to be recorded in your mind that while issuing search reports and title reports, we shall be diligent in this behalf. Friends, with this I conclude. I express my gratitude and thanks to Nilesh and all your office bearers. Thank you very much. Before parting with, I'll make a note, friends. We are seeing nowadays the most of the virus affected people, they are from our fraternity, our brothers and sisters, they are succumbing to the disease, and therefore please take proper care, wear a mask and sanitation, and please take care, stay at home. Thank you very much.
I would like to request you here. Thank you, first of all, thank you for the insightful lecture. Our participants want to take this opportunity to ask you a few questions. So with your permission, if I can go ahead. Thank you so much, sir.
Yes.
So the first question is, does MHARERA have a format in which a title search report is to be issued?
Yes. Now age has been, the practicing age, or rather the practicing years, it has been increased from 3 years to 10 years. Why for? That is the question, right? Madam, that is the question, no?
Sir, the question is, does MHARERA have its own format of title search report? Like every advocate gives his title search report in their individual format.
Yes. In the rules of the MHARERA of 2017, there is a format given, but that format is not a complete format is the guideline to be followed. Similar format is to be found in Ramniklal's judgment. This format of the Maharera is nothing but borrowing, rather it is the blueprint in respect of Romney-Clark's judgment. Nevertheless, in the rules, format of the search report has been given, a title report has been given. I'll make a note, I'll make a point of difference. Format is different and your opinions are different. There can be contents provided, but analysis of the content, they cannot be formed. You have to provide for your own opinion in respect of such contents.
Thank you, sir. So the next question is, if an advocate mentions in the disclaimer of the title report that he or she will not be held liable for any consequential loss or punitive loss, will he still be liable?
Madam, this is called as contracting out. And such a contracting out is not permitted in law. Whenever there is a statutory duty imposed on you, then by your contract or by simply stating that I will not be responsible for wrong done by me, it is not permissible. And therefore, even though it is written by a lawyer as a footnote that whatever wrong is committed in the opinion, I will not be responsible. Rather, this will be more erroneous on his behalf to say so. It is irrational to say so. And he will be responsible irrespective of this. At the most, we can say, what we can say that this search report is issued on the basis of the documents supplied by client to me, as well as record of rights supplied by him to me, and also in respect of the information given by him to me. But you cannot write such a note.
Thank you, sir. So the next question is, what are the other provisions in law under which a title certificate is to be issued in case of property, other than provisions applicable for issuing title of promoter under MOFA?
No, rather I will say that there are only these two laws which requires for your statutory issuance of the title certificate. See, say for instance, there are two provisions. One, issuing of a title certificate at the instance of the client, and issuing of the title certificate when that is required by law. In these two laws, there is a necessity of the title report provided for, while ordinarily title report may or may not be provided for. In these two laws, RERA and MOFA, search report or title certification is must.
Thank you, sir. This is a long question. I'll try to make it as short as possible. If a sale deed is executed and registered and the entire consideration is paid to the owner who acknowledges the receipt of this consideration, but he has not recorded his name on the 712 extract for more than 10 years, and the subsequent purchaser, that is the promoter, acquires this land and gets his name recorded on the 712 extract. In such a case, how should the advocate issue the report if the earlier purchaser did not take any action or objection?
So look here, in the question itself, answer is given. Because it is said that first document was registered before 10 years. This should have been reflected where in the search. So there is a negligence on the part of the advocate, because this would have been reflected in the search itself. And what is not reflected in your own search, you cannot take the benefit thereof. Irrespective of that, if document was executed, then entry in the record of right is not creating any right, but that simply gives a proof thereof. So in this case, lawyer will not be excused.
Thank you, sir. We have a couple of questions flooding in, but this will be the last question due to the paucity in time. The last question, sir, is, can the Tahsildar or SDO declare or issue certificate that a tribal holding a land subject to section 36 and section 36A of MLRC in the right, in other right column in 712 extract is non-tribal person, whether such certificate is legal?
Yes, this is issued especially when, say for instance, there is Minor Minerals Excavation Act, and sometimes there is a Minor Minerals Excavation Act, provisions are violated, there is unlawful digging, and then there is a penalty imposed, then that is recorded as a arrears of revenue in the 712 extract. And I will look here as a different aspect. In state of Uttar Pradesh and some other states, title certificate is issued by the registrar's office. In some of the states in India, title certificate is issued not by the lawyers, but by the government office itself. And in respect of Maharashtra, there was one committee constituted by the state of Maharashtra, that was Land Titling Committee. Fortunately, I had an opportunity to work in that committee, and now in Maharashtra state, within short time, rules are being changed by as per the report of this Land Titling Committee of Government of Maharashtra, wherein there is insurance as to title is to be afforded, and government system is to be subjected to change, wherein now, as somebody has asked a question, that a sale deed was executed 10 years before. No entry was made effective for 10 years. Then another sale deed was effected. Now builder has constructed a building and so many flat purchasers they have been defrauded. So as to avoid such complications, now the Land Titling Committee of Government of Maharashtra has suggested for change in the rules, and thereafter when this entire system is corrected or completed, title report like Uttar Pradesh state will be issued by the government of Maharashtra only. Till then, we have to undertake this work.
Thank you so much, sir. Thank you so much for your time. I'm going to ask Advocate Sudeep Kenjarkar to take over from here and express gratitude and the vote of thanks.
Thank you, Sujata. Thank you, Sujata ma'am. Sir, I'm Advocate Sudeep Kenjarkar, Vice President of RERA Practicing Association, on behalf of our association and Bar Association Maharera and Maharit Mumbai. Thank you, sir, for your valuable and precious guidance for today's lecture. Hope we shall get your valuable guidance in future also. Thank you so much, sir.
Okay, thank you.
Thank you, sir. Thank you very much, sir. Thank
Thank
you
you.
very much. It was really very good lecture, sir. Thank you.
Thank you. Thank you.